Ayanda.
No, he's there.
They speak in these. No, it wouldn't be on. Six of 20. Do you have a document with you? I don't know if this is the original. No. I think you are there. Yes. Just the one you got. Thank you.
Okay. They're taking me down that way. Ifika nini?
Okwakuba ready bona mcimbi. Ngiyakawusele nge-21.
Huh? Hayi bo. Oh, okay.
National.
National. Sounding like you're into the house.
It's based on kuphila kaloku. Kodwa besibhalele isidate isikani. Ukuthi isizo cases zabo. Xa besibhalile attribute ho. Yes, it's the process.
Yeah. Umke nomuka lo yena.
But you say
sepitolo.
Yeah, but you say answer ne
You still think bakaba appointing. said she left a break.
Okay, just tell the media when he comes up now, no photographs. Advocate Solomon?
This thing is on, eh?
It's fine. I've requested that they don't take further photographs.
Yes.
It comes up now.
Yes, of course.
So I think they'll respect that wish. Please the court, my lady. I appear on behalf of the state together with my colleague, Advocate Kari Gamwa.
Thank you.
Yes, good morning, my lady. I'm here on behalf of the accused, Mr. Botha, together with my court counsel.
Thank you so much. Yes, thank you. This matter came on my role as a pre-trial, and then I was consulted in chambers yesterday by Mr. de Kock, leading counsel for the state, together with Ms. Karigwambo, and then Advocate Solomons and the members of the defence team, to indicate that a plea and sentence agreement had been entered into in terms of Section 105, capital A. So, Mr. de Kock, I will give you the opportunity to take the floor. Thank you.
Thank you, my lady. I confirm that it is indeed correct that the state and the defence have entered into a plea and sentence agreement in respect of this matter. I submit that the formal and substantial requirements in terms of section 105 capital A have been complied with, in that the investigating officers in this matter have been fully consulted regarding the contents of the agreement, the admissions made in the document by the accused. The state has also consulted with the parents of the deceased and the family of the deceased fully regarding this matter, and have explained in great detail the contents of the document and the processes that are expected in court today. So, with the leave of the court, I request that the state put the charges to the accused, and that the accused be requested to plead to those charges.
Just as a matter of formality, Mr. de Kock, while you're on your feet, could you just confirm that you've been authorized in writing by Ms. Luyanda Botha, the National Director of Public Prosecutions, as required in terms of Section 105 capital A, to negotiate and enter into the agreement with the accused?
That's correct, my lady. And that authorization is indeed attached to the documents that will be presented to the court.
Thank you. Proceed. Who's going to proceed with the charges?
Thank you, my lady. In the matter of the state versus Luyanda Botha, the state alleges that the accused is guilty of the following offences. 1. Rape, as contemplated in Section 3 of the Criminal Law, Sexual Offences and Related Matters Amendment Act, number 32 of 2007, read with Sections 256 and 261 of the Criminal Procedure Act, number 51 of 1977, and read with the provisions of Section 51(1) and Part 1 of Schedule 2 of the Criminal Law Amendment Act, number 105 of 1997. 2. Rape as contemplated in Section 3 of the Criminal Law, Sexual Offences and Related Matters Amendment Act, number 32 of 2007, subject to the same provisions as read out in Count 1. Count 3, murder, read with the provisions of Section 51(1) of the Criminal Law Amendment Act, 105 of 1997, as amended. And count 4, defeating or obstructing the administration of justice.
Thank you, Mr. Luyanda Botha. Did you hear the charges against you?
Yes, I heard the charges.
You understand the charges against you?
I understand the charges.
Thank you, Mr. Solomon.
Yes, I confirm that the accused understands the charges against him, my lady, and it has been discussed with him in full. So he is pleading guilty on all 4 counts, my lady.
Thank you. You may have a seat. Thank you. I see in terms of the conviction and sentence agreement that you had pleaded guilty. I'm going to ask you a few questions so I can be satisfied that the plea and sentence agreement in terms of Section 105 capital A meets with the necessary requirements. I understand from your counsel, Mr. Solomons, that he had explained your rights to you, and I want to ask you a few questions. Have you entered into this agreement freely and voluntarily, without force or duress? You are nodding. May I assume that's a yes?
Yes, ma'am.
Thank you. Do you understand that if I accept the conviction and sentence agreement, that you would be accordingly so convicted, that you would therefore have a criminal record, and that you would be sentenced accordingly in terms of this agreement?
Yes, ma'am, I do.
Thank you. You may proceed.
Yes. I think the court is going to read the first part, my lady.
Thank you, my lady. My lady, I invite the court to receive the relevant documents that have been prepared by the state and the defense in this matter as Exhibit A.
Thank you. Just for the record, I received a photocopy of yesterday afternoon, so you're handing up to me the originals thereof.
That's correct, my lady. With the leave of the court, the state and the defense have agreed that the state will read into the record the preamble, the background, the plea of guilty and admissions made by the accused, the plea explanation as set out in Part C of the document will be read out by the legal representative of Mr. Botha. And the concluding parts of the document, including paragraph I, that sets out the agreement in respect of a just sentence, will be read out by the state.
Thank you, Representative.
Thank you very much. In respect of the preamble contains the charges that I've already set out to the court. So with your leave, I'm not going to read that again.
Thank you.
I'll start at D1 of the document. I'm the Director of Public Prosecutions. I've been duly authorized by the National Director of Public Prosecutions as required in terms of Section 105A of Act 51 of 1977 to negotiate and enter into an agreement with the accused. The authorization is attached as Annexure A.
Yeah, thank you, Mr. de Kock. I think we can carry on. Some of these aspects have already been canvassed, so I think I've got it here. I'm satisfied with it. You can proceed with the background.
So, thank you very much. I then proceed to read the background. The deceased, Uyinene Mrwetyana, was born on the 20th of April, 2000. She was a 19-year-old at the time of her death on the 24th of August, 2019. She was a student at the University of Cape Town. The accused was employed as a teller at the Claridge Post Office in Claremont. And on Saturday, the 24th of August 2019, the deceased entered the post office to collect a parcel. The accused was on duty and alone inside the post office. The deceased was not seen alive again. The plea of guilty and admissions are as follows. The accused, as indicated, is represented in this matter. The charges have already been indicated to the court. The accused freely and voluntarily admits that on or about Saturday, the 24th of August 2019, and at or near Claremont Post Office, Iman Maroon Road, Claremont, in the district of Wynberg, he unlawfully and intentionally committed an act of sexual penetration with the complainant, to wit, Uyinene Mrwetyana, a 19-year-old female, by penetrating her vagina with his fingers without her consent. The provisions of Section 51(1) of Act 105 of 1997, as indicated previously, is applicable. The accused freely and voluntarily admits that on or about Saturday, the 24th of August 2019, and at or near the Claremont Post Office, in the road already indicated by me, he unlawfully and intentionally committed an act of sexual penetration with the complainant, to wit, Uyinene Mrwetyana, a 19-year-old female, by penetrating the vagina with his penis and or an object unknown to the state without her consent. And similarly, the provisions in terms of the minimum sentence legislation, is applicable to that. The accused freely and voluntarily admits that on or about the 24th of August 2019 and at or near the Claremont Post Office, as indicated above, a 19-year-old female, the deceased in this matter, he assaulted her by hitting her repeatedly on her head with a blunt object and or inflicting other violence unknown to the state on her. The provisions of Section 51 is similarly applicable to the charge of murder as set out above. The accused furthermore admits in the document that he committed the offence of defeating or obstructing the administration of justice, to wit that he disposed of the body of the deceased by dumping it on a field, dousing it with an accelerant, and having his car cleaned in order to mislead the police as to the true method of a death, the identity of the perpetrator, and to destroy forensic evidence which acts defeated or obstructed the administration of justice. Those are the formal admissions made by the accused. In terms of the detail of the plea explanation, Advocate Solomon and his learned colleague will then proceed further to inform the court of that. Thank you very much.
Thank you. May I proceed?
As it pleases you, my lady. I will be reading the C-section to record my lady. I, Luyanda Botha, was employed as a teller at the Claremont Post Office in Claremont. I first interacted with the deceased on the 8th of August 2019 when she entered Claremont Post Office to inquire about a parcel she was expecting. The parcel contained clothing she had purchased online. The parcel was not available, and I told the deceased that I would contact her to tell her when the parcel was available. The parcel arrived at the post office on the 16th of August 2019. I registered the parcel on the same day. On Saturday, the 24th of August 2019, I reported for duty at Claremont Post Office in Claremont. The post office was due to close at 1 o'clock. Shortly before 1 o'clock, my colleague Suraya Abdullah went home as per an agreement between us, leaving me alone in the post office. I contacted the deceased to inform her that the parcel was available for collection. The deceased used the taxi service to travel from her residence, Roscommon University student accommodation in Claremont, to the Claremont Post Office. She arrived at the post office after closing time. I unlocked the front door and the deceased entered. When she entered the post office, we were alone in a locked post office. When the deceased searched her bag to pay the requisite customs fees, I started making sexual advances towards her. The deceased did not respond and looked scared. I grabbed her by the waist and forcibly pulled her closer to me. I proceeded to sexually touch the deceased against her will. I inserted my fingers into her vagina. I then inserted my penis into her vagina. The deceased fought me whilst I sexually violated her. She managed to run to the door, but I caught up with her and knocked her to the ground. I dragged the deceased to the safe inside the post office. I locked her up inside the safe. The deceased screamed whilst inside the safe. I choked the deceased, and she fought back and kicked me. I took a 2-kilogram weight used to weigh packages received at the post office and used it to bludgeon the deceased to death. I targeted her head. I left the post office and consumed alcohol outside a nearby liquor outlet. I returned to the post office shortly thereafter. I covered the body of the deceased with cushions, a blanket, and a jersey as she lay in the safe. I left the post office in the evening. I returned to the post office in the early hours of Sunday, the 25th of August 2019. The area where I attacked the deceased and where her body lay was covered in the blood of the deceased. I proceeded to clean up the inside of the post office to remove the blood from the scene. I waited until it was dark and requested the security officer who patrolled the outside perimeter of the post office to allow me to park my motor vehicle in the yard of the post office. Once parked in the yard, I placed the body of the deceased in a large postal mail bag and carried her body to my motor vehicle. I transported the body of the deceased to a field in Lingaletu West and dumped it in a shallow hole. I then drove to a nearby petrol station and purchased petrol. I returned to where I disposed of the body of the deceased, dosed her with petrol, and then set her alight. I admit that I did so to defeat or obstruct the course of justice by destroying forensic evidence. I admit that I hired someone to clean my car to destroy the forensic evidence. I admit that the body of the deceased was discovered on Monday, the 26th of August, 2019. I admit that she was correctly identified as Uyinene Mrwetyana. I admit that the body of the deceased did not sustain any further injuries from the moment the murder was committed until the post-mortem examination was performed on it by Dr. Verster on the 2nd and the 4th of September 2019. The content of the post-mortem report is attached and is admitted as correct and is attached as Annexure B. I admit that the DNA retrieved from the body of the deceased during the post-mortem examination was semen and that I was the depositor thereof, and the report is attached as Annexure C. I admit that the photographs taken at the Claremont Post Office correctly reflects the scene where the deceased was killed and is attached as Annexure D. I admit that the photographs taken correctly reflects the scene where the body of the deceased was discovered in Lingaletu West and attached as Annexure E. I admit that the photographs taken correctly reflects the post-mortem examination and is attached as Annexure F. I admit that I acted with a full appreciation of the wrongfulness of my actions when I committed the above-mentioned acts, and I am liable for my actions as I had the intention to rape and kill the deceased. I also intended to defeat or obstruct the course of justice. I admit that the above-mentioned court has the necessary jurisdiction to entertain this matter. As it pleases you, my lady.
Thank you, my lady. Then, if I can proceed further, in relation to the factors taken into account for the purpose of the sentence agreement, the factors that the state and the defense have taken into account. Firstly, the provisions of Section 51(1) of Act 105 of 1997 are applicable in that the crimes of rape and murder are mentioned in Part 1 of Schedule 2 of the said Act, therefore carrying a minimum sentence of life imprisonment in respect of counts 1 to 3. The seriousness of the offences that the accused has committed, the interest of the community, as well as the personal circumstances of the accused, were all considered and taken into account by both parties. The aggravating factors of this case can be summarized as follows. The deceased was a 19-year-old student who was murdered in a callous and vicious manner for no reason other than she rebuffed the sexual offences, the sexual advances of the accused. The deceased was a first-year student at the University of Cape Town in the prime of her life, had much to offer the country, and the opportunity to reach her full potential was brutally cut off by the accused. The family and the friends of the deceased are greatly traumatized by the fact that the deceased was killed in what should have been a safe public space. The accused amplified the trauma and the heartache of the family of the deceased by setting a body alight, forcing them to have DNA tests done to confirm her identity. The treatment of the deceased body before death and undignified. The accused misused his position as a postal worker to gain the trust of the deceased, causing her to enter the post office. The accused has previous convictions. The report is attached as per Annexure G. And in terms of that report, the accused has a previous conviction of robbery that was committed in 1999 and which the accused received a sentence of 8 years imprisonment, of which 3 years were suspended. And then lastly, gender-based violence, particularly the killing of women, is a scourge on our society. And women are no longer safe from people like the accused. I will now request that Mr. Solomons read out the particulars, the personal particulars in respect of the accused, and I will read out the final part of the document thereof.
Yes, please report, my lady. The accused is 42 years old. He attended high school and completed grade 12. He got married in 2015, but is currently estranged from his wife. The accused got 2 children, aged 3 and 14. The youngest child stays in Umtata, and the eldest stays with the estranged wife. At the time of the incident, he was employed as a teller at the Plea post office. The accused was remorseful, hence he made a confession and pointing out immediately upon his arrest. Thank you, my lady.
Thank you, my lady. Then furthermore, whether or not there were substantial and compelling circumstances that in our discussions, the parties agree that in this matter there are no substantial and compelling factors present which warrant a departure from the applicable minimum sentence of life imprisonment. So, the agreement in respect of a just sentence, the proposed agreement to this court is the following: that the agreed sentence in respect of the counts as set out in the indictment, in respect of count 1, life imprisonment, count 2, life imprisonment, count 3, life imprisonment, and count 4, 5 years imprisonment. That in terms of section 282 of Act 51 of 1977, the sentence imposed on count 4 shall run concurrently with the sentence imposed on count 1. That the accused in terms of section 276B of the Criminal Procedure Act, Act 51 of 1977, a non-parole period of 25 years is fixed, during which the accused shall not be placed on parole. In terms of section 103 of the Firearms Control Act, Act 60 of 2000, the accused is unfit to possess a firearm. Those are the submissions of the defense and the state, my lady. I submit that the documents are in order, and I request that the court proceeds accordingly. Thank you very much.
Thank you. Before I proceed, I did give access to the media for broadcasting, photographing, filming the proceedings. The restriction is, of course, that the exhibits, the image exhibits, are of a sensitive and graphic nature, and I do believe it's in public interest, and to respect the legacy of this young lady, Uyinene Mrwetyana, the sensitivity for her family and others and loved ones, that I direct that no such images can be captured or filmed. Thank you. Mr. Botha, you have heard the submissions made by the defense on your behalf and the state. I am satisfied that the conviction and sentence agreement is in accordance with justice, and accordingly I convict you as charged. Now, as regarding to the sentence, the court convicts you as charged. As regarding the sentence, I'll read out as follows. On the count 1, which is in short rape by inserting your fingers into the vagina of the deceased, life imprisonment. Yes. Count 2, which is rape by inserting the accused penis into the vagina of the deceased, life imprisonment. On count 3, for the unlawful and wrongful killing, which is the murder of Uyinene, life imprisonment. And count 4, 5 years direct imprisonment, which essentially is defeating or obstruction of the administration of justice by disposing of her body, setting it alight, and cleaning up various forensic evidence in the course of obstructing the administration of justice. I further order that in terms of Section 280, subsection 2 of Act 51 of 1977, the sentence imposed on count 4 shall run concurrently with the sentence imposed on count 1. I need not have to say this, it happens ex lege, but these sentences will run concurrently in that it consists of life imprisonment. That the accused is furthermore ordered in terms of Section 276 capital B of the Criminal Procedure Act 51 of 1977, a non-parole period of 25 years is fixed, during which the accused shall not be placed on parole. And lastly, in terms of Section 103 of the Firearms Control Act 60 of 2000, the accused is unfit to possess a firearm. Further to that, I wish to address the family of Uyinene Mrwetyana. But before I do so, is there anything that you, Mr. Botha, would like to say through me as the court to the loved ones and the family?
Ma'am, I do not have anything verbally, but I've organized something in writing that will go to the family of Uyinene as well as to the rest of South Africa. But I will ask my lawyer to handle that.
Thank you, Mr. Solomon.
Yes, the accused is asked not to read it out in court, my lady, because it's a lengthy document, and I still need to discuss it with my office before we can dispose of this document.
Thank you. You will make sure the family will have it.
Indeed, my lady.
Thank you. Mr. de Kock, is there anything that you would like to add?
Thank you. My lady, we have consulted with the family of the deceased, in particular the mother and the father. And they have requested, they have prepared in consultation with themselves a statement. And they've requested, with the leave of the court, that that statement be read to the court.
Will we
So,
be reading it out?
I'll ask my colleague to read it out.
Thank you. Yes, Ms. Karibon.
As it pleases the court, my lady. The Mrwetyana family statement. Says court date 15 November 2019. Marked for the attention of the National Prosecuting Authority and addressed to the Honourable Judge. My lady, the 24th of August 2019 marks the first day of a redefined version of our family. The day started out like any other. As it progressed, upon the realization that we could not be reached, our worst fears crept in, and that initial trepidation has since developed into an ocean of emotions which have coalesced into agony. This day also marked a turning point, after which privacy for the family became a rare privilege. We have since directly or indirectly been in the national and international spotlight because of the catastrophic loss of our precious daughter, Uyinene. Our once quiet and private daily lives are now watched with sorrow and pity. Whilst the country and the world at large show us immense love and support that we sincerely appreciate, we are always drawn back to that moment in time when this catastrophic tragedy befell us. We were a small family of 4, 2 men and 2 women. This diversity in our family presented multiple thoughts and generational opinions that would emerge at every dinner table discussion, phone call, and so on. The sudden annihilation of our princess has emphatically altered our collective being, as her voice, which was distinct, crisp, and filled with warmth and affection, is now gone. She has left an everlasting void. Her father is gutted and deeply saddened that he could not even view her body due to how badly damaged it was from the despicable act committed by the accused. He is left with an internally open wound which has made it difficult to reconcile with this tragedy. Isona, her brother,
is devastated that his younger sister, whom he cherished so much, went through this horrible experience and had her life cut short in this manner. He has been left alone now, as his biggest cheerleader and advisor is no more. They had so much hope for the future, including times when they would be parents themselves. All those dreams and future ideals have been unceremoniously stolen away from both Isona and Uyinene. What a loss. I, on the other hand, as Isona and Uyinene's mother, as well as their father's wife, have the gigantic and godly responsibility of safeguarding the well-being of my family. The intense trauma from the loss of my daughter is a daily burden that is excruciatingly hard to bear. She had become my call a friend when I needed to chat, my loudspeaker when I could not fully express myself, my pacemaker. She had become me. No words can fully describe my hurt, let alone that of the entire family. We invested a lot in Uyi, as we had first-hand understanding of her dreams and all that she wished to achieve with her life. We did so enthusiastically, as she was such a pleasant young lady with every right to believe that the world was an oyster. She had hopes and dreams of conquering the local and international scenes in the media and film industry. Boy, oh boy, a naturally talented child, a dream deferred indeed. How is she to achieve those plans now? We are hopeful that Nene's murder is not in vain. We look beyond our loss, as her death awakened a movement in South Africa and the world over. It is fact, though, that every day we are reminded that we are the biggest losers. We remember your beautiful, deep, husky voice with pleasure, and so imagine the voice when you bravely fought your perpetrator, denouncing the ill and evil he put you through. We have sleepless nights imagining the fear of being faced with a monster who presented himself to you as a trusted civil servant in a place that is viewed as a national asset to service the community. We are stuck with the question, why? Why was it really necessary? The trauma is totally unbearable, but we will not allow the end to define you, Uyinene. We constantly feel the hurt concealed beneath veneer of coping and surviving. Our hearts continue to bleed for you. We pray for your soul, and we are holding on to the joyous memories and life experiences we had together. The foundation and scholarship in your honor will help us further your great deeds, and we shall impact young lives who will go on to spread the love to the world over. We have full confidence in the justice system of our country. We are not okay without you, Belikazi. We cannot be. Your friends who have become family are not okay. Nene, the women of this country are not okay. Young girls are not okay. We are a bleeding country. It is painful, a pain no parent should ever go through. Thank you, Milady. Do you wish to have this handed in as an exhibit?
You may. Exhibit number?
I think it would be H, Milady.
Thank you so much.
Thank you. Those are all the submissions then on behalf of further
Thank you.
submissions on behalf of the state. Thank you.
Thank you to both councils, all the councils for your hard work, much appreciated. To the Mrwetyana family, some of whom are sitting on my left and some that's sitting in the gallery. To the loved ones of Uyinene, her parents, family members, friends, fellow students, and her mentors. I was informed that some of you had travelled here today from far, and undoubtedly it would have been an arduous and emotionally crippling journey for you. This court can only attempt to understand the grief and the anguish that you would have felt when your daughter did not return home on that fateful day in August this year. And then the fear that had unfolded as day turned into night. The despair that you would have felt as this crime had been uncovered, and learning what had happened in the last moments of Uyinene's life and the disrespect her remains would have been subjected to. The accused, Mr. Botha, had now been convicted and sentenced by this court. I must say that no sentence or punishment that this court can or had imposed would bring back your lovely daughter and loved one. However, I hope that it brings closure to this chapter of the legal proceedings of this harrowing and life-changing event for your family and the community that you represent. Hopefully, too, it will slowly help you in the difficult path and the painful journey of your healing. The court has heard that Uyinene fought bravely and courageously to ward off this gruesome attack on her. This was indeed a heinous and cruel act and crime. Though it may be cold comfort to you today, it is not without significance that she was a fighter and clearly had a fighting spirit for her life. She is and she will remain a hero and an iconic champion in the pursuit of reducing and ending the epidemic of gender-based violence. Indeed, the killing, violence and abuse of women, our daughters, our sisters, mothers, wives, baby girls, had become a daily social ill in our country and across the globe. Uyinene's fighting spirit and her legacy will continue to give a voice to other women who suffer daily as victims as gender-based violence offences, and the efforts by our society will be propelled into success as our justice system and other various stakeholders in our society bring to an end the siege or attack on women. Ultimately, the court wishes you well in your journey back home, but more so, I wish you well in the healing of your grief, so that you ultimately will be able to celebrate the life of Uyinene, the beautiful things and the warmth and the joy that she brought to you, and the happy memories of her that will continue to live on within you. Thank you. With those few words, court will adjourn.
As it pleases the court, I release the court.